So today we're talking about 4 additional rulings that came down from the Supreme Court. These were on additional Second Amendment rulings that were sort of placed on hold until the previous ruling was made. Now let's go ahead and jump into the video and listen and find out. Really, let's get to the summary of what happened here with these.
Bruin reaffirmed that text, as informed by history, is the correct type of analysis when you're dealing with the Second Amendment. Because of that ruling, the question became, what would the court do with all of these other Second Amendment cases that were on hold before the Supreme Court? Well, we received an order today from the Supreme Court, and it essentially issued GVRs in all of these cases.
Okay, so remember, this is the previous ruling that had come out by the Supreme Court, and it talked about text as informed by history versus Chevron deference. And the Chevron deference is that two-step process. This two-step process looks at sort of like weighs the needs of the government against the needs of the individual. And basically what the Supreme Court said was, no, when it comes to the Second Amendment, you can't use this Chevron deference. You can't decide that the needs of the government outweigh this individual right of every American citizen with regards to the Second Amendment.
Now, if you're not aware of what a GVR order is, it is a type of order issued by the Supreme Court in which the court grants a petition for certiorari, vacates the decision of the court below, and remands the case back down for further proceedings. So that's why it's called a GVR. It's a grant, vacate, and remand.
Basically, they just take this and they kick it back down to the lower courts, and they say, you guys need to look at this again.
An order of this sort is typically appropriate when there has been a change in legal circumstances subsequent to the lower court's decision.
Okay, he's just going to cover what they do. They basically just taken these 4 cases, and kicking them back down to the lower courts.
So this was a solid win for the Second Amendment. The best case scenario would have been that the Supreme Court would take up some of these cases and finally issue an official ruling on some of these issues, but this was kind of the second best option. Now the lower courts are being told that their prior decisions in these cases were incorrect, they've been vacated, and now they must rehear these cases and issues in light of the correct analysis as outlined in the Bruin opinion.
So, like I said, they're kicked back down to the lower courts. These lower courts have to look back at these cases again, and they have to use it using text as informed by history. They can't use basically this two-step Chevron deference process that they were using to analyze these cases. Yeah, it kind of puts them in a bit of a box there that they're going to have to do the right thing. Now, could they still find a creative way to get around this? Yeah, probably so. Could this mean that one of these cases yet again ends up before the Supreme Court? Yes, that's possible as well, especially with some of these circuit courts like the Ninth. You know, they love to be creative. I'll just leave it at that.